Welcome back, dear students. Today, we are going to learn the drafting of an application to sue as indigent person in accordance with Order 33 of CPC. And second item, we will learn the drafting of appeal from orders. So first of all, we will learn the drafting of an application to sue as an indigent person. So dear students, the initial question is as to who is an indigent person, you must know. Indigent person means a person who is not possessed of sufficient means and sufficient means is also defined in Order 33. A person who is not possessed of sufficient means other than properties exempted from attachment in execution of a decree under section 60 CPC and subject matter of the suit to enable him to pay court fees required by law. And if no court fees is required and he does not have the properties worth rupees 1,000 other than properties exempted from attachment in execution of a decree under section 60 CPC and subject matter of the suit. So if his total assets are less than 1,000 rupees, then he is an indigent person. But how to decide whether a person is indigent or not? The civil court will conduct an inquiry into the indigent status of the plaintiff. This inquiry is to be made by the court by taking evidence of both the parties and government counsel. The application to sue as indigent person will contain all the ingredients of a plaint, and this application to sue as pauper or indigent person is to be presented personally by the indigent person or his authorized agent, but not by an advocate. The applicant or agent of the applicant will be examined by the court or by the court commissioner. And if this application to sue as indigent person is allowed, then this application shall be deemed to be a plaint. And the plaint shall be heard without payment of any court fees. This is the mandate of Order 33, Rule 8 of CPC. Court may allow a pleader to such an indigent person, but permission to sue as indigent person may be withdrawn if pauper person succeeds in his suit. Then court fees and other costs shall be calculated and recovered from the party as ordered by the court. It may be recovered either from plaintiff or from defendant. But if the suit of the pauper fails or the permission is withdrawn, then you see court fees shall be recovered from indigent person. So indigent person is allowed to file a suit without payment of court fees in the beginning, but once his suit fails or permission to sue as an indigent person is withdrawn by the court, then court fees shall be recovered from indigent person. And if the indigent person, that is a plaintiff who was allowed to file the suit without payment of court fee, if he dies and suit abates, then dear students, the court fees shall be recoverable from the estate of the deceased indigent or pauper. See how the law is strict. Then if any set-off or counterclaim is made by the indigent person, you know, set-off or counterclaim are treated as a separate plaint, so they are subject to same rules. If an indigent person wants to defend set-off or counterclaim, or if he has made a set-off or counterclaim in his WS, then that is as good as a plaint. So he has to prove before the court that he is an indigent person, and only then he will be allowed to set off or counterclaim without payment of court fees. Now, dear students, with this little knowledge of the indigent person or the pauper person. Now we start the drafting of actual application on behalf of an indigent person so that court may allow him to file his plaint without payment of court fees. So as usual, first of all, you are supposed to draft the name of the court. Here the name of the court in this illustration which I have chosen is the Court of Civil Judge Junior Division. So the first line to be drafted by you is in the Court of Civil Judge Junior Division, Noida, District Gautam Buddha Nagar, UP. Suit number dash dash of 2017. Now name of the plaintiff or the applicant, A son of B, aged about 43 years, resident of village Asgarpur, Noida, Gautam Buddha Nagar, UP. He is the plaintiff and applicant also, versus the other party is X son of Y, aged about 59 years, resident of village Asgarpur, Noida, District Gautam Buddha Nagar, UP, is our defendant. Center heading is to be drafted like this: application for suing as pauper or indigent person or former pauperess. Three words have the same meaning: pauper, indigent person, or former pauperess. Now the facts are to be written in small paragraphs to be numbered consecutively, and all the ingredients of a plaint must be included in this application for suing as indigent person. The reason is that if this application is allowed, then this application shall be treated as a plaint. So para number 1, that the plaintiff applicant is a below poverty line, poor resident of village Askarpur, Noida, Gautam Buddha Nagar, UP, and is living in an ancestral hut which has a window, a ventilator on the eastern wall. The said hut with open space was allotted to the father of the plaintiff on 1/1/1953 by the then Gaon Sabha Askarpur, Meerut. The plaintiff is the only surviving heir of his father. Dear students, you must know that Meerut was a big district and Ghaziabad and Gautam Buddha Nagar were part of Meerut in 1953. So when this hut was allotted to the father of the plaintiff, at that time, the jurisdiction of Gaon Sabha, Asgarpur, was in district Meerut. Now it is in Noida. Para 2, that the plaintiff is not possessed of sufficient means and is unable to pay the requisite court fees prescribed by law for filing this plaint. His total assets are less than rupees 1,000. This is the requirement which has to prove that the total assets of the plaintiff applicant are less than 1,000 rupees. Para 3, that the defendant is a neighbor of the plaintiff and has threatened him on 31st December 2016 that he will close the window and ventilator of the hut, public room of the plaintiff by construction of a wall. He has started the construction of said wall by digging its foundation. Para 4, that the plaintiff applicant is using easement of light and air from window and ventilator of the eastern wall of his hut since the time of his forefathers. The plaintiff himself is enjoying the said easementary rights since his childhood for the last more than 40 years. The plaintiff has acquired the said easementary rights by prescription, by uninterrupted use for the last more than 20 years. Dear students, you know that easementary rights by prescription, they get mature when a person is using the easement at least for last 20 years. Para 5, that if the defendant succeeds in his lawful or unlawful design and constructs a wall adjoining to the eastern wall of the plaintiff will suffer irreparable loss and damages inasmuch as his hut will not remain worth living, and in the absence of light and air, the plaintiff is likely to suffer from so many diseases and illnesses. Para 6, that the cause of action arose on 31st December 2016 when the defendant threatened the plaintiff that he will construct a wall and will close the window and ventilator of the plaintiff. The defendant has started digging the foundation of the said wall and has collected bricks, sand, and cement on the spot. The labor is also working on the spot. Para 7. That the valuation of the suit is tentatively fixed at rupees 500 only. Para 8. That the suit is filed without any delay within period of limitation. And para 9. That this honorable court has jurisdiction to hear and decide the present suit. So, dear students, you have mentioned all the four legal ingredients of a plaint, that is CVLJ, C for cause of action, V for valuation, L for limitation, and J for jurisdiction. Now, the last paragraph, the plaintiff applicant most respectfully prays that first prayer is A, the present application under Order 33 may kindly be allowed and plaintiff be allowed to present the suit as form of purpose without payment of required court fees. Second relief is B, that suit of the plaintiff for easementary right of light and air through his window and ventilator may kindly be decreed with cost. Now, plaintiff applicant will put his signatures on this application, and date of application is also to be drafted like here 1/1/2017. Then you are supposed to write down the schedule of the property of plaintiff. All that hut of plaintiff allotted by Gaon Sabha Asgarpur, measuring about 15 feet into 20 feet, bearing number 33 in village Asgarpur, Noida, district Gautam Buddha Nagar, UP, having lawn on the eastern side, measuring 10 feet into 20 feet, bounded and butted as above. On the northern side, there is road of Gaon Sabha. In the south, there is Chak Road of Gaon Sabha. Western side is hut of Z, and eastern side house of X is situated. And the total valuation of movable and immovable properties of the plaintiff applicant is rupees 650 only, which is less than 1,000. Then now verification is required. Verification center heading will be verification. I, A, the applicant plaintiff above mentioned, do hereby verify that the contents of this application from paragraph 1 to 5 are true to my personal knowledge, and those of paragraph 6 to 9 are true to legal advice received, which all I believe to be true. After verification, again, the signatures of plaintiff A are required. And it is to be mentioned and drafted here that presented personally by A plaintiff. Again, signature of plaintiff A are required, and date of presentation is also to be mentioned here as 1/1/2017. Now, next item, dear students, which we are going to learn today, is the drafting of an appeal. Drafting an appeal from orders under Order 43 of CPC. Dear students, you know that every decree of civil code is appealable. First appeal is a matter of right. Similarly, certain orders which are mentioned in Order 43 of CPC are appealable. All orders are not appealable. Only those orders are appealable which are mentioned in section 104 and Order 43 Rule 1 CPC, which contains the list of appealable orders. Dear students, you must know the distinction between an order and a decree before you start drafting of memorandum of appeal from particular order. You see, word order has been defined in section 2 clause 14 of CPC as the formal expression of any decision of a civil court which is not a decree. Order is also a formal expression of any decision of a civil court, but that is not decree. Thus, an adjudication of a civil court which does not fall within the definition of decree is an order. If you start drafting of an appeal from orders, you will have to see the legal position mentioned in Order 43 and Section 104 of CPC. Section 104 to 108 of CPC deals with appeals from orders. Accordingly, an appeal lies from all those orders which are mentioned in Section 104 and in Order 43 Rule 1. But no other order is applicable. No other order is applicable unless it falls in the list given in Section 104 and Order 43 Rule 1. But you are not handicapped. If an order is not appealable, all other non-appealable orders can be attacked in an appeal from the final decree. Suppose order was passed by the court during pendency of the suit and the order is not appealable. Then suit will proceed, decree will be passed, and when you will file appeal against that decree, at that time you are entitled to attack that non-appealable order also, that the order dated so and so was passed without jurisdiction or it was passed against the law. But dear students, please keep in mind that only one appeal is allowed from orders. Second appeal is not allowed. No appeal lies from the order passed in appeal under Section 104 CPC, meaning thereby that no second appeal lies from orders. You, as I told you, you have a right to challenge the non-appealable orders in appeal against decree. Where any order is made under this code against any party and thereupon a judgment is pronounced against such a party and a decree is drawn up, such party may, in an appeal against the decree, contend that such order should not have been made and the judgment should not have been pronounced. This is the mandate of Order 43, Rule 1, capital A of CPC, wherein attack against non-appealable orders can be made on the grounds A, that there is error, defect, or irregularity in the order. B, second ground, that such error, defect, or irregularity has affected the decision of the case. Then, dear students, you must take care of one item more, that interlocutory orders are not, if not challenged, they amount to res judicata. Res judicata applies to two stages of the same litigation also. Hence, if any interlocutory order has not been challenged, the same would operate as res judicata at all subsequent stages of the suit, and no party would be allowed to set the clock back during the pendency of the proceedings. It thus gives finality to such orders. But correctness of such orders, however, can be challenged by aggrieved party in a regular appeal to be filed from the final decree according to Section 105. Dear students, there is a limitation also. How long you can file appeal against an order? An appeal from an order can be filed in a high court within 90 days and in any other court within 30 days from the date of the order. And forum of appeal shall be appeal from orders in cases in which they are appealable. Appeal shall lie to the court to which an appeal would lie from the decree in the suit in which order is made. This is the mandate of Section 106. So appellate court will remain the same. Whether you are filing appeal against order or appeal against decree, appellate court remains the same. And dear students, please take note that where such order is made by a court other than a high court, in exercise of appellate jurisdiction like district judge, then appeal shall lie to the high court. This is the mandate of Section 106 of CPC. Now, with this knowledge at the back of our mind, now we will start drafting of an appeal or memorandum of appeal from orders. As usual, first of all, you will have to select the name of the court. Since this is an appeal, so minimum name of the court will be the Court of District Judge, because that is the first appellate court available to you in the hierarchy of courts. So selection of the name of the court, drafting of name of the court is the most essential part of your drafting. So in this illustration, the name of the court we have selected in the court of District Judge Gautam Buddha Nagar, UP. Appeal from order number dash dash of 2017. The name and address of appellant and respondents are to be drafted by you at your own. So here the appellant is X son of Y, aged about 45 years, resident of flat number 509, Designers Park, Sector 62, Noida, Gautam Buddha Nagar is our appellant, versus respondent is A son of B, aged about 40 years, resident of flat number 918, Pavilion Court 10, JP Greens, Wishtown, Sector 128, Noida, Gautam Buddha Nagar, UP is our respondent. Center heading will be Appeal against order dated 20th November 2017. Bracket may you are supposed to write down arising out of original suit number, say it was 2 of 2017. Because you know the suit number. You do not know appeal number against the order, but you know the original suit number. Now the opening paragraph will be drafted like this. The above named defendant appellant appeals against the ex parte judgment and decree of the civil court, civil judge, senior division Noida, passed in original suit number 2 of 2017, dated 15th October 2017, and order dated 20th November 2017, whereby the application of the defendant under Order 9 Rule 13 CPC was dismissed by the learned lower court and sets forth the following grounds of objection to the order and decree appealed from. Now you are supposed to mention the value of the suit. It was say 6 lakh rupees. The valuation of the appeal will remain same, 6 lakh rupees. Court fees paid same as in plaint. The amount of court fees in memorandum of appeal will remain same as was paid in the plaint. Now the opening paragraph is to be drafted like this. The defendant appellant above named most respectfully submits as under. The appellant is defendant in the original suit and is as such well conversant with the facts of the case. The appellant had moved an application under Order 9 Rule 13 CPC for setting aside ex parte decree dated 15th October 2017 before the Court of Civil Justice Senior Division Noida, but the London lower court was pleased to reject the application of the petitioner on 20th November 2017, hence this appeal. Now you are supposed to draft the grounds of appeal by mentioning all those grounds in small paragraphs to be numbered consecutively. Para number 1 or ground of appeal number 1. That the appellant defendant had duly received the summons issued by the lower court for the filing WS in this case. Para 2. That the date of filing of the WS was 1st October 2017. Para 3. That the appellant defendant was going to the office of his counsel, Shri XYZ Advocate, on 30th September 2017 on his bike for signing WS. But on the way, he met with an accident with a car. He fell unconscious and was taken to Max Hospital by the police. He remained admitted in the hospital for 40 days, where his hip bone was replaced. Para 4. That the appellant was released from hospital on 10th November 2017. See, these are the reasons as to why he could not appear before the date fixed and ex parte decree was passed against the defendant. Para 5. That the appellant went to the office of his counsel and requested for filing of WS. His counsel took the defendant to the office of Civil Judge, Senior Division Noida, where his counsel filed his wakalatnama along with an application for inspection of the file. Para 6. On inspection of the file, it was revealed that Honorable Court was pleased to decide the case ex parte on 15th October 2017 and an ex parte decree was also drawn accordingly. Para 7. that the defendant was prevented from filing WS because of reasons beyond his control on account of his unfortunate accident. Para 8. That the impugned order dated 20th November 2017 is harsh, unreasonable, and arbitrary, inasmuch as the said order was passed without affording adequate opportunity of hearing to the defendant appellant. Then para 9. That the impugned order is violative of Article 14 of Constitution of India and hence unconstitutional. Para 10. That if ex parte judgment and consequent decree is not set aside, the defendant appellant will suffer irreparable loss and injury. Para 11. That it is in the interest of justice that ex parte judgment dated 15th October 2017 and consequent decree arising out of said judgment and order dated 20th November 2017, whereby the application for setting aside ex parte order was rejected, be set aside. Lastly, the prayer. The first prayer is, it is therefore most respectfully prayed that this appeal may kindly be allowed. Ex parte judgment dated 15th October 2017 and consequent decree arising out of the said judgment along with order dated 20th November 2017 may kindly be set aside in the interest of justice. And B, second relief is B, the defendant may kindly be allowed to file his WS, which is being filed along with this application. Date of filing this appeal is to be drafted like 21st November 2017 and signatures of appellant defendant are required on this memorandum of appeal. And since this memorandum of appeal has been drafted by some counsel, so you are supposed to write down through counsel XYZ advocate. Again, the signature of XYZ advocate are required on this memorandum of appeal. Lastly, the verification is to be done like verification of a plaint. I, ex appellant named above, do hereby verify that the contents of this memorandum of appeal from paragraph 1 to 11 are true and correct to my knowledge. After verification, again the signature of ex appellant are required. Date of filing is again to be mentioned here as 21st November 2017 and place of drafting is to be mentioned as Gautam Buddha. So dear students, this is how today we have learned the drafting of a suit on behalf of indigent person, and second item we have learned the drafting of memorandum of appeal against the orders. So dear students, thank you very much.